Welcome to Sakshi TV Special Immigration Talk Show. I'm your host, Shivani Raj. For today's show, we have Ms. Prashanthi Reddy. Please note that Sakshi TV now has 4 immigration shows every week: on Tuesdays with lawyer Srinivas Kaveti, on Wednesdays with Prashanthi Reddy in English, on Thursdays with Parvat Neni, and on Fridays with Banu and Indra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on the show is not a legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, please contact the attorney directly. Ms. Reddy needs no introduction, but if you need consultation, you can definitely log on to their site, www.reddyesq.com site. Please note that this site has given a lot of wealth of information needed for the US immigrations and updates. So without any further delay, let's welcome Ms. Reddy on our show. Ms. Reddy, I hope you're doing well. Welcome.
Thank you. Thank you, Shivani.
Yes.
I hope you're well as well.
Yes, thank you, Ms. Reddy. I'm doing great. So, Ms. Reddy, today we thought we're going to discuss a little about the H1B alternatives and also a little about the second lottery that has happened. But before we get onto the topic, are there any latest immigration updates that we have to talk about?
Yes, and we can discuss the updates, after the topic. So let's start with the topic first. So with reference to the second H1B lottery, we know that a lot has been happening with H1B petitions, and the second lottery is a result of a significant increase in registrations this year. USCIS has reported 780,884 registrations for FY 2024. That's an increase of about 61% over, the 483,927 registrations from 2023. So that's, 61% increase. If you look at the percentage of the number of registrations picked, this is based on the first lottery, of course, not on the second lottery. 2024, only 14.6% was the pick rate. 2023 was 26.9%. 22 was 43%, almost 44%, and before that it was 46%. So if you see the trend that the demand has been increasing, multiple registrations have been increasing, and the pick rate has been decreasing from last 4-5 years. It's decreased from 46% to 14%. This year has been an exception. It's been 14%. Maybe might have gone up a little bit because of the second lottery, and some registrations were picked in the second lottery as well. So might have increased to about 20-25% in the second, with the calculation of the second lottery as well. But still, it's quite a low percentage. And if you look at the as I was saying, there's also an increase in just the number of registrations, because forget about the multiple registrations. We know that the increase in registrations of 780,000, 61% increase, is because of multiple registrations, because people have been filing more than one registrations per person. But even without that, if you look at the number of single registrations, there has been an increase there also. It's 350,000 when compared to about 211,000 in 22. So there's been an increase in single registrations as well, which basically means that, all the talk about multiple registrations and what it's doing to the system is overshadowing the actual problem, which is the fact that, the annual H1B limit is very low. The numbers available is only 85,000, while if you look at the number of single registrations, which is 350,000, which shows the demand for work visas. So the number of picks would only be 25%, even if there weren't any single multiple registrations. So that's the demand that there is. So that's the real problem, not the multiple registrations. The real problem is that there are very few H1B numbers available and that the H1B numbers should be increased. So the issue with multiple registrations is, as per USCIS, they're saying that companies that typically have the most H1B petitions approved are not engaging seemingly in this wrongdoing. It seems to be that that a small number of companies are responsible for entering all these multiple registrations into the lottery multiple times. And they're basically doing this with no intent of really filing the H1. So there are a lot of companies that have floated just to file H1B registrations. What they're doing is taking money from people in India, saying that they'll file a registration for them, filing the registration and then not filing the actual H1 because they never really had an intent of doing that, and they don't have a job for them. So, I think USCIS is going after those kind of employers because they have used up a lot of the quota. And USCIS thinks, rightfully so, that they're responsible for the multiple registration debacle that we've had this year. So what is the solution to this multiple registrations problem? I think the only way of doing this is doing the lottery based on the person's passport number. So not doing the lottery based on the number of registrations, but picking out the unique passport ID numbers and putting them through the lottery process. Then, if the beneficiary gets picked, he'll get one chance to get picked. He'll have only one number. But then after he gets picked, he can always decide which employer he wants to join, even if he filed for through multiple employers. So I think that's a great solution to the problem, but let's see what USCIS will come up with. We don't know if this will be the solution that they come up with, or they think of something else to curb the issue of multiple registrations. Just a reminder, for the second lottery, the deadline to file is October 31st, 2023. The first day to file was August 2nd. So your time period is between August 2nd and October 31st. So you have about 90 days to file your second lottery pick. You also have to remember that you can't file your first lottery pick during this time. A lot of people have told me that they have not filed their H1 in the first lottery. It was picked in the first lottery. Can they now do it in the second lottery? No. This time given is only for those cases that were picked in the second lottery. Okay, so something to keep in mind. Also, a lot of people are asking if there is a likelihood of a third round of lottery system for 2024. It's difficult to say because registrations have been at an all-time high. The registration picks, rather, have been at an all-time high. They picked 188,400 registrations. The number of cases that can be filed are only 85,000. So you can see the reason that there's such a high pick rate this year is because not many people are filing. So the first time they picked a certain number of cases, 100 and something cases, and then they didn't have enough filing. So now they're picked about 70,000 odd cases. And if they don't have enough filings this lottery also, then they might have a third lottery. So it's difficult to say. We really have to wait and see what happens.
Yes.
So I think with that we can go to the alternatives. Now that the lottery, the cap is getting over or will be over, and also for those people who didn't get picked in the lottery, and we can't depend on the chances of a third lottery being there. So it's a time to think about alternatives to the H1. Is there any other work visa that we can come on other than the H1? So the first is the cap exempt H1. So if you are an employer who is an institution of higher education or a non-profit related or affiliated to an institution of higher education or a non-profit or governmental research organization, non-profit research organization or a government research organization, then you can file the H1 without worrying about the cap. You're not subject to the cap in that situation. So an institution of higher education is basically a university. Non-profit related to an institution of higher education is like a teaching hospital, for example, a hospital that's related to an educational institution like Bronx Science, or some other Cornell Medical School, medical hospital. Non-profit research is basically a non-profit research organization or a government research organization. That's evident as to what that is. Now you have to remember, it's not just the employer being one of these organizations. If you're a consulting company, you can have an end client that is one of these organizations. And that will be sufficient as well. Another alternative is the O1 or the STEM O1. So basically, if you cannot file the H1, but you are a person who has an extraordinary ability in the sciences or the arts, in education, in business, in athletics, whatever field it might be, if you have extraordinary ability, then you will be able to find an employer can sponsor you and you can file an O1. In order to show extraordinary ability, there are certain criteria that you have to meet. You basically have to show that you're the best in whatever you're doing. You have to show that you've received accolades, you've received awards, whether it be national or international, that you are considered to be the top by other experts in your field. So you have a lot of reference letters. You've invented something that is useful, and you've made a lot of money through that invention. You have a patent on something, and so these are some examples of who can qualify. You're a businessman, highly successful. Your company is on NASDAQ or is being publicly traded. So these are some examples of successful or people with extraordinary ability. You might be a scientist who's has discovered something in your particular field. So there can be many instances in which a person is extraordinary, has extraordinary ability. The other alternative to the H1 is the L1. The L1 is the intra-company transferee. This is when, for example, you have a company in the US and you have a company in India, and the companies are related either through a subsidiary, as a subsidiary or a parent, or as an affiliate. If there is that relationship and if that employee has worked in your company at least for the last 1 year out of the last 3 years, doing, if you're L1A, then executive level, managerial level work, or if you're L1B, then they have been using that specialty knowledge kind of work, then you can qualify for an L1A or L1B. And you can come into the country. There's no cap on that L1. There's no prevailing wage, so it's in many ways better than a H1. Also, the L2 is allowed to work. Your spouse is allowed to work automatically. And or if you're L1A, then you qualify for EB1. So EB1 for the green card is the best possible category because the numbers are the best and more easily available than EB2 or EB3. So you'll get the green card faster when compared to the EB2 or EB3 people. In addition to that, you also have TN, the TN visa category. The TN visa category is available for Canadian and Mexican citizens. And as long as you are working in one of the designated occupations as per NAFTA, and that's, you can find those designated occupations for TN online. And as long as you qualify based on, that list of what qualifications are needed for each occupation, then you are able to work very easily in that on that TN visa. Also, for a TN, you can just apply at the port of entry. You don't have to apply at the consulate. You don't have to apply, at the USCIS, get an approval, and then go to the consulate. For the Mexican TN, you have to apply at the consulate. but you don't have to get any prior approval at USCIS. So this is a really good, and there's no cap, no quota for this TN visa. So it's really good visa. So anybody who, if you're an employer, you can find your resources in these countries. In addition to the L1, you also have other country-specific visas, such as the E3 for Australia. So Australian citizens can go to the consulate and apply directly for the E3. The requirement is same as the H1. It has to be in a specialty occupation area. Again, it's not subject to the cap. In the same way, Singapore, Chile, citizens can apply for H1B1. There is a cap for this, but it's usually not used. It's 10,000, and it's never, the cap is not, doesn't usually get over. So these are good options, the H1B1 and the E3. Next option is the E1 and E2, treaty trader, treaty investor. People from certain countries, and again, the designated countries of E1 and E2 are available online. But if you belong to that country, you can either bring your employee or you can bring yourself as a treaty trader or treaty investor. You're basically a business person setting up a company, or already having a company here, investing a certain amount of money, then you can bring in your employee or you can come in yourself. So that's also an alternative to the H1. And of course, you have the F1, which is the student visa. A student can work on OPT after completion of their studies, or they can work on CPT while they're studying. Either way, they're allowed to work and study at the same time. And students often use this CPT and OPT option when they don't get picked in the cap. This is how they continue working for a few years until they actually get picked. So this is an option that, without it, I don't know what students would do. They would have to go back to their home country, I guess. So it's a very important option for students. Some more options. The last option, I think, is filing directly a green card. If you're filing a green card directly, then they don't have to come on a non-immigrant work visa. This is especially useful for people who are on EB1 because the numbers are easily available on EB1. It doesn't take that long. But for EB2 and EB3, it's useful only for countries other than China or India, because China and India are heavily backlogged. Visa numbers are not available for them, so they will not be able to come in for many years. So applying for a green card for them doesn't make any sense for an employer, because that job will not be vacant for that long. But definitely makes sense for other countries, because they can come in within a time span if the visa numbers are current of about a year or so, which is not too bad, because the H1 also cap cases, they don't, you have to wait until October anyway to come in. So with that we've completed the H1B alternatives. Also, another alternative to the H1 is if you are presently on a H1, what you can do, if you're presently on a cap, if you're presently on a cap exempt H1. So basically what you can do is get yourself on a H1 with a non-profit organization or a cap exempt organization. And once you're on a H1, you can then apply for a concurrent H1, which is cap subject. So cap exempt, as you know, there is no cap. You can apply anytime. Then that way you can have two H1s concurrently. First you apply for cap exempt organization. You have a part-time H1 there, and then you apply for cap subject, and then you get a full-time H1 with them. So that's another way, a trick around the H1B cap.
Yes.
Now coming to some of the updates or issues that we have seen recently with H1B people working who are traveling from outside the country. So issues faced by H1B people at the port of entry, some recent cases. I thought we'll discuss that since we have a few more minutes. So people, if the officer at the port of entry is not convinced that all your documents are in order, they can take you in for secondary inspection. Secondary inspection pretty much means that they're taking you into another room where you'll be interviewed by an officer, one officer or two officers, depending on the situation. And then they can ask you many questions. They can then make you sign a document with all the answers that you've given to those questions, because they usually record those questions. And accordingly, then they can either, deny your entry, or they can even start removal proceedings. So this is what secondary inspection is. And sometimes it happens, you have to go into secondary inspection. So what happens usually, the reason why they might, what documentation they might look at with secondary inspection is your electronic devices. Recently, we've been seeing a lot of H1B visa holders. I mean, everyone carries their electronic devices with them, right? Their cell phones, their laptops, their iPads, right? So officers are often taking those devices and inspecting them. So they're checking your email, they're looking at WhatsApp, they're looking at your social media, Facebook, Instagram, your phone conversations, email conversations, etc. And documents also. They're looking at any documents that they can find to see if there's any issues with national security, number one, and to see if there are any documents that will show inconsistencies or raise any doubts with reference to your work in the US. So for all those people who are carrying their devices, please make sure you have, you're not carrying, you don't have all that information on your phone. I would suggest delete your social media posts. Any incriminating information, you should remove it. It might not be information that you did anything wrong, but it might look bad and then, unnecessarily raise doubts and lead to questions. So that type of information you should remove. Generally, we see that USCIS or CBP will look at your previous resume. So in a recent case, there was a person that came in on a H1 at the port of entry. They looked at his laptop, I believe, and there was an old resume there. And, a lot of consulting companies tend to bolster the resumes. They add experience to the resume so that the person becomes more marketable. And they present that resume to the client. So that resume, CBP officers found, and then based on that, they removed this person from the country, and he is now, he's barred from coming into the country for the next 10 years. So just be careful with documents like this. Make sure you don't carry any of those documents on your phone or other electronic devices. The problem with expedited removal is, they don't give you a chance, the officers don't give you a chance to actually withdraw your application. If you withdraw your application, you can always go and apply for a new visa and then try to come in again. But they usually, with removals, there's a bar attached to it for 10 years or 5 years, which will potentially stop you from re-entering the US. So that's the problem. And we don't have control of whether they will do an expedited removal or they will just allow you to withdraw your application, right? So that's something to keep in mind when you're traveling, and take all the precautions that you possibly can. Most of the time, if you're already on a H1 and you're traveling, it might make sense to carry your pay records, payroll summaries, your timesheets, your work schedules, any work documentary, examples of work products created, employment records, employment history records, such as your promotion, your transfers, etc., pay change. So that all that shows that you have been working on a H1B and shows that you have been maintaining your status. That's for people who are re-entering the country when they were on H1. Also, there's some additional tips for people who are entering on a H1. Answer the questions when CBP officer asks you a question. Answer to the point. Limit your answer to the questions that they're asking. Be prepared to answer questions with reference to duties, employment, your location where you're working. They want to make sure you filed an amended petition if required. That's why they're asking about work location. Always be polite to the CBP officers. Even if the officer is being combative or rude, always, respond respectfully. You may not be allowed to call anyone, but if you think that the CBP officer is out of line, you can always ask for a supervisor and ask to speak to a supervisor. So these are some additional tips. I think with this, we're done. We'll do the updates next week.
Yes. Thank you again, Ms. Reddy, for tuning on to our show. It was lovely having you. Thank you again for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you. Bye.
Bye, Ms. Reddy.